Hi, this is Patrick Henry, the CEO of QuestFusion with The Real Deal What Matters. I'm here today with Jeremy Glaser, who's a partner at the law firm Mintz Levin. Jeremy also serves as the co-chair of the firm's venture capital and emerging companies practice. I've known Jeremy for many years. He's a wonderful guy and an incredible attorney, highly recognized, really, around the U.S. as one of the top venture capital lawyers in the country. So welcome to the show, Jeremy.
Thank you, Patrick.
Today we're going to be talking about the JOBS Act. This is a piece of legislation that I think President Obama signed a few years ago. It's highly complicated. There's a couple key parts of it called Title II and Title III that's especially relevant to entrepreneurs in terms of getting financings done. I guess Title II deals with kind of traditional startup financing, and Title III deals with crowdfunding. So Jeremy's an expert on these things. I'm not. I don't even know what the JOBS acronym means, but I'm sure Jeremy will tell us that and many other useful things for the entrepreneurs out there.
Well, thanks, Patrick. Yeah, so the JOBS Act is actually the Jumpstart Our Businesses Act, sort of a cute acronym that Congress came up with at a time when obviously the economy was not doing very well.
Sure.
And they were trying to put some things in to try to create more jobs.
Yeah.
And the belief was that if we opened up financing for early stage companies, that obviously that would help them grow, perhaps have them hire more people and create more jobs.
Sure.
So how is this relevant to entrepreneurs? It's relevant to entrepreneurs in that we now have really 3 new ways to raise money for startups that we didn't have before.
Okay.
And so you're right, there's these different titles, and so Title II is what we call the general solicitation financing. So
Yeah.
what does that mean? Traditionally, companies raise money in a private placement that had very strict rules about how you could contact your investors. And one of those rules was you couldn't put an ad in the newspaper. You couldn't go out and start calling people on the phone randomly who you didn't know.
Yeah.
You couldn't put the fact that you were trying to raise money out on the internet or on a website or on Twitter. So those rules were obviously becoming a little bit difficult to police in this new world.
Sure.
Where everybody was on social media, everybody had websites, and people were talking about their companies, including their financing rounds.
Yeah.
So the good news is Congress and the SEC recognized this and said, let's change the rule. Let's go ahead and create the ability for companies to raise money, but use what they call general solicitation, which was a sort of a legalistic term, but basically means you can do the things that I just said you couldn't do.
Okay.
So now you can do your offering and present it on your website or put it on an internet portal like Angel's List and make it widely available.
Okay.
Now there's a catch, as there always is. There's some restrictions that you have to meet in order to do a general solicitation, and the key one is that you have to do some very special due diligencing on the investors to determine that in fact they are accredited investors.
Okay.
And again, I don't think we want to get into all the details of what that is, but just to forewarn the entrepreneurs that before you try to go down the road of doing an offering, whether it's a regular private placement where you're not going to be putting it out on an open internet portal or on your website, or if you're going to be going down the road of doing a general solicitation offering to accredited investors only, which is what Title II allows, you better make sure you're talking to an attorney. You better make sure you have the right documentation, because if you don't, you have some very serious legal issues that could cause you to have to basically give the money back.
Okay.
Which you don't want to ever be in that position.
Yeah, for sure.
So, but that's still, it's a very valuable option, and it definitely gives companies a much broader ability to reach out to potential accredited investors to fund their businesses. Now, the part that got more attention, but is actually not even effective yet, is Title III.
Well, before we get there, because that's the crowdfunding stuff, right? So I've got a couple questions about Title II.
Sure.
So I remember when we took Entropic public, and we also did private rounds of financing, as you're aware. There's something called Reg A or Regulation A, and then when we did the IPO, where we did it was more of a general solicitation, obviously using investment bankers,
Of course.
there was a lot of things we had to do in terms of the prospectus and the proxy statement and all those kinds of things. Do those things go away in this new form of general solicitation in a private stock offering, or how does all that stuff work?
Yeah, so it's really a great question, because I've actually referred to these, general solicitation offerings as a private public offering.
Okay.
Because that's sort of what they are.
Yeah.
But the beauty of it is you don't have to do a registration statement. You don't have to file it with the SEC.
Yeah.
You don't have to go through that approval process you talked about.
Right.
Because you're limiting your sales only to people who are certified under this procedure as accredited investors. So it's a little different than the public offering that you went through,
Okay.
where you went through that SEC process and you were able to offer those securities to anybody. They were open to
Yeah.
anybody, not just accredited investors.
So
By
let's say,
limiting
for
it-
instance, I am an angel investor.
Yes.
I'm very selective about what I invest in, but do I need to go through a process of being a credited investor, or what does that look like? Do I show my certificate to the entrepreneur and say, hey, I'm good to go, or they have to go through some type of screening process to identify me, and I don't have to do anything myself, they just have to do some type of thing?
Yeah, so this is exactly the stickling point with these new accredited investor, public offerings.
Sure.
And that is that there is a process that the company has to go through to confirm that you, Patrick, for example, are an accredited investor, meaning that you meet the requirements of $1 million net worth,
Okay.
or $200,000 of income individually.
So there's a checklist that they have to go through, but then they have to.
But you have to certify. You have to actually get. So, for example, there's
Yeah.
a litany of ways that the SEC laid out in their regulations. That's what we call a safe harbor. That if you do these things, we're going to view that you met the requirement.
Okay.
And those include things like seeing your tax returns, or getting a certification from your accountant, or from your investment banker or financial advisor. So there needs to be more than just, oh, hi, yes, I meet that, I'm accredited.
Yeah.
You have to actually provide some independent evidence of the fact that you meet these requirements. Now, there are some services that have popped up
Yeah.
that will do this, and so when you talked about showing up with the certificate,
Yeah.
that can work.
Yeah.
If you provide all that information to these services, and then they do that checking, and then they confirm that in fact you meet those tests.
Okay, but that isn't required if you're doing the traditional private financing, where I'm an angel investor, and you're not doing a general solicitation. If I want to put 25 grand, 50 grand, 100 grand into a deal, and it's not under these general solicitation requirements, it's the way that it used to work.
Exactly. Those rules are still in place. And,
Okay.
and you still, whenever you do one of those investments, I'm sure you've made these. You
Yeah.
have to sign a document
Sure.
that you say, I'm an accredited investor.
Yeah.
And usually you have to check a box, or
Sure.
my net worth's more than $1 million,
Yeah.
or my income is more than $200,000 a year.
Right.
You still have to do that.
Yeah.
So that hasn't changed. And that's all you have to do if the company has not used general solicitation in raising that private round.
Now, on the general solicitation part, though, part of the benefit of the public offering process is that you do have to disclose a lot of information. A lot of it, like for an example, in the risk factors. I mean, a lot of these things are corner case things, but if you have good attorneys, they're going to have you put every single possible corner case in there. And if you actually read the full disclosures in these proxy statements and these these S1s, you would never invest in it. so what level of disclosure is required? Is there any level of disclosure required other than like a pitch deck for a startup when they do this kind of modified version of a general solicitation?
So it's a great question, and there's sort of two different ways to look at this. So from the perspective of, like in the public offering, where the SEC has very specific rules about what has to be in a disclosure document
Yeah.
to take a company public, when you look at a private placement, whether it's using general solicitation or not,
Yeah.
because those are limited to accredited investors, and that's the key.
Yeah.
If the only investors in that financing are accredited, there actually are no specific disclosure rules.
Okay.
Now, you still have the issue, and without getting too technical, there's this rule called 10b-5 that basically says that anybody who sells a security cannot misstate material information or omit material information.
Right.
So you still have to meet that standard.
Yeah.
So the reality is you do a disclosure document, and if you want to be smart, you disclose the relevant risks of the business so that your investors are knowledgeable and you can feel comfortable that they're not going to come back to you later and say, hey, you violated Rule 10b-5 because you didn't disclose all material facts about your business.
So as a safeguard then, if you are an entrepreneur, you're a startup CEO, it's prudent to do, I would call it like a mini S1, but you're not filing it with the SEC, you're just doing that as a document that you're handing to these accredited investors before they invest so that you're covered by safe harbor by doing that.
Exactly.
Is that the
I
right way to
advise,
think about it?
absolutely, I advise all companies to do some sort of a disclosure document,
Yeah.
and it can vary. I mean, it really depends upon the size of the offering, the number of the investors you're going to be reaching out to,
Sure.
the way you're going to be reaching out to the investors, the relationship you have with them before,
Yeah.
will all drive decisions. So there's not any one size fits all.
Okay.
You need to really, again, address this with someone who does this a lot, who
Yeah.
can guide you so that you're not overspending on the title
Right.
but also you don't want to be under disclosing and creating potential
And have some
liability
risk.
for yourself.
Sure. Okay. All right. So that's Title II. So Title III, which hasn't gone into effect, I guess it goes into effect May this year or something.
It's like 180 days post when the rules came out. I don't have the exact date
Okay.
here, but yes,
Okay.
the rules are out finally. We waited a long time
Yeah.
for the SEC to come out with rules about what we call crowdfunding, which I know people have been very excited about.
Yeah.
Those rules have been released, not yet effective, but you're right, they will be effective in the coming months.
So now when I think of crowdfunding, I think of like Kickstarter and things like this, that it's more pre-sales of a product where I need to raise some money. I'm going to go out to the general public. I'm not offering an equity financing. I'm just doing kind of pre-sales of my latest gadget. In fact, I bought something called the Thing Charger. The Thing Charger, so it's basically something you stick into your wall outlet and you can charge your phones on it.
Sure.
And it was a crowdfunding campaign, and it was a pre-sales campaign. And I was hoping to have my Thing Chargers as stocking stuffers for the Christmas holidays, but I just got them like a couple days ago. But that's different than the crowdfunding you're talking about, which is basically going to the general public to raise equity financing.
Selling equity, right.
Okay.
So in fact, one way to avoid confusion is the thing you did with your wall charger,
Yeah.
or through Kickstarter and those types of things.
Yeah.
We refer to that as crowdsourcing,
Okay.
as opposed to crowdfunding. To try to
Okay.
make that distinction
Okay.
between when you're basically, like you said, pre-purchasing a product
Right.
versus investing in equity.
Okay.
So the pre-purchasing of a product was okay because you were not selling securities.
Right.
When the SEC gets involved is when you're selling securities, and
Right.
that's crowdfunding.
Okay.
So that's now what we're about to have available. Now, look, I know a lot of entrepreneurs were excited about having this, and people thought it was going to be a big deal, and so I don't want to totally downplay it. Yes, it is wonderful that companies, when those rules are in effect, will be able to go out and sell up to $1 million of securities in any 12-month period of time to pretty much anybody.
Okay.
That it's not going to be limited only to accredited investors like we were
Okay.
just talking about.
Mhm.
It will, in fact, be just like your public offering when you went out with Entropic,
Right.
where you can sell to everybody. However, there's a lot of limitations. There's a form that has to get filed with the SEC, just like your public offering. Smaller, less disclosure, less
Okay.
complicated, but there's an approval time and a process. You have to only sell these securities through basically approved portals. So there's a lot of restrictions that most attorneys, and I include myself in this, believe that this is not going to get used that much.
Okay.
That the cost of doing these, $500,000 is one level, or $1 million at the higher level fundraisings is probably not going to make sense for most companies because of the cost involved to raise such a small amount of money. Now, $500,000, $1 million today is usually being raised in angel rounds with convertible notes, with very basic preferred stock financings,
Right.
and private placements. Those can be done very inexpensively, and you don't have the regulatory overlay. So that's why most of us think that crowdfunding in the way of Title III is probably not going to really be used in any significant way by tech companies that have traditionally gone down the angel route and the venture capital route.
Right.
Now that said, I think it's sort of interesting though from the perspective of like loyalty programs, right?
Mhm.
So, for example, you might have a favorite restaurant.
Mm-hmm.
My guess is that you might view your relationship to that restaurant differently if you owned some of it.
Mm-hmm.
You might go more often. You might refer your friends there more often, right?
Mhm.
There might be a real advantage to smaller, almost like retail operations that can benefit from like consumer loyalty to go down this route and use that to sell some equity to their customers to build that brand loyalty.
Yeah.
I think that's sort of an interesting opportunity.
Well, when you talk about the cost being prohibitive, I mean, that's kind of what was resonating with me, because I know the cost of, going through the public offering process, the S-1 filings, proxy statement, all this other kind of stuff. It's very expensive, especially when you use high-priced guys like Jeremy. But so you got a mini version of this, the mini-me version.
It's very mini. It's
So it's
certainly
like-
not
so-
going to be anywhere near the cost of doing a full-on IPO,
Okay.
which can be, $1 million plus
Yeah.
in legal fees alone.
Yeah, just in legal fees,
No,
and then
this
you've
won't
got
be-
the
this won't
accounting.
be
Then you have the
anything
accounting
big.
and stuff on top of it, and then you have to pay your bankers. So it's very expensive.
But you're gonna have legal fees. You're gonna have accounting fees because there is a requirement that the financials be reviewed
Yeah.
if it's under $500,000 or audited if it's
Yeah.
between 500,000 and $1 million.
Mhm.
You're gonna have these portals involved. You're gonna take
So
some fees.
ballpark it for me. I mean, how much money are we talking about to put like a shelf registration crowdfunding campaign out there?
To be honest with you, I don't know because the rules aren't out yet and we haven't done them.
Okay.
So I don't have a sense of what these are going to cost.
But your just general sense, knowing the process, is it's likely going to be prohibitively expensive unless there's some other psychic benefit of being, customer loyalty.
Right. So what I do know is
Yeah.
if you come to me and you want to raise $1 million on a convertible note deal,
Yeah.
we can do that for probably under $5,000 of total legal fees.
Okay.
I don't think there's any way that the total legal fees on a crowdfunding deal are going to be anywhere near that.
Okay. So basically, on a relative basis, there's better ways in your mind, more likely going to be better ways to do that.
Agreed.
Okay. So any other kind of key things that you wanted to cover about the JOBS Act?
Well, I think the one thing I do want to raise is there's another aspect that actually is effective that came out recently called Reg A+.
Okay.
And Reg A+ is actually something I'm very excited about.
Okay.
It allows companies to raise up to $20 million under one tier or up to $50 million in another tier. Again, to anybody. It's like your public offering,
Yeah.
but on a much more reduced regulatory scale. And in fact, there's been a number of these Reg A+ deals filed, and so we do have a sense of what the legal fees are on those,
Yeah.
because they're required to disclose them in their filing document.
Okay.
Now, what's interesting is there's a huge wide band. You have some that are being filed literally as low as $10,000. They're saying that what the legal fees were, but there are others that are showing $300,000.
Sure.
Now, they're all still way less than the traditional
A public offering.
public
yeah.
offering,
Yeah.
but there's a pretty wide range.
Yeah.
But I think Reg A+ is a very interesting alternative for companies versus going down the traditional venture capital route, because you can sell your securities broadly. There is a regulatory process. There is a filing with the SEC. There are requirements around reviewed financials. But because you can raise so much more money, $20 million, $50 million, as opposed to the $500,000 or the $1 million under crowdfunding,
Yeah.
I think Reg A+ is going to be used a lot more by traditional tech companies.
So this is kind of would open up the door for kind of syndicates of angel investors, super angels more likely if you're talking about the bigger numbers, as opposed to traditional venture capital putting that kind of money into deals.
Absolutely.
Okay. Awesome. This is super helpful. I learned a lot. Hopefully this was valuable for the entrepreneurs out there. This is Patrick Henry, the CEO of QuestFusion, with The Real Deal, What Matters.